Hello everyone, this is Crypto BitLaw back with another blockchain legal brief, and today we're going to be covering the SEC versus Ripple case, in particular a recent update in the case that will serve as a pivotal milestone as to how the case will progress moving forward. But before we dive in, if you enjoy this content, please hit that like button and subscribe to our channel. Also, you can follow us on Twitter. Our handle is at CryptoBitLaw. And with that said, we're going to jump right on in, but be forewarned, this is kind of a complex issue, so we're going to cover the entire article that really has to deal with explaining what's going on in this case, and then wrap it up and give some sort of analysis after that. So with that said, let's jump right on in. All right, so as we can see here, Cointelegraph reports that the SEC versus Ripple case, there's a new development, and they're going to pretty much explain how two 2012 memos can turn the tide in the milestone crypto case. And they say, we will soon know if Ripple's executives were warned of the possibility of an SEC lawsuit ahead of XRP's launch. It states, Ripple's court battle with the United States Securities and Exchange Commission has recently seen new developments that, according to some observers, could foreshadow an impending resolution of this massively consequential case. February 17th marks the deadline for Ripple to unseal a series of 2012 documents whose contents will likely sway the opinions of both the court and the public toward either one side or another. In another plot twist, the court's decision to treat some of the SEC's documents as open to discovery could set a groundbreaking precedent for similar cases involving U.S. executive agencies. Here's where things stand ahead of the next round of the showdown. It continues, the SEC's lawsuit against Ripple Labs Incorporated, filed on December 23, 2020, alleges that the company raised upwards of $1.3 billion by selling the XRP token without registering it as a security, which is what the agency considers it to be. Ripple's argument is that XRP is a tool that facilitates international payments rather than an unregistered investment product, and that the agency's jurisdiction does not extend to the token and its sales. This is not the first lawsuit against a digital asset issuer that the securities regulator has brought. However, the vast majority of such cases end in a settlement instead of going to trial. In this scenario, individual crypto firms yield to the SEC's demands and pay penalties to be let go. The regulator's case never reaches the stage where it can be scrutinized by a judge or a jury panel. No precedent for similar cases in the future is set. So pretty much what they're saying there is that based on everything that's happened in the past in terms of the SEC actually suing any of these crypto projects that engaged in, I guess what they consider an ICO of securities, issuing a token that pretty much acts as a security, none of these cases have actually been heard on the merits by a judge or a jury. So because of that, we don't really have any sort of jurisprudential precedent to go on. Nothing really set in the law that would determine what happens for cases that come after that in terms of precedent. Continuing on, they say, unlike many others, Ripple chose to go all the way and get into a legal fistfight. If the SEC scores a W, court precedent will reinforce the agency's claim for regulating much of the crypto market using, quote, tried and tested securities laws. If Ripple prevails, the need for a more nuanced regulatory regime tailored to various types of digital assets will become more evident than ever. It goes without saying that the SEC's regulatory ambitions would suffer a major blow if the latter scenario plays out. While both Ripple as a company and the vociferous online community of its token supporters known as the XRP Army have been a divisive presence in the crypto space, the lawsuit's resolution will affect the entire U.S. digital asset industry. One of the pillars of Ripple's defense is that it simply did not know that its XRP token could be categorized as a security. The SEC, the argument goes, should have notified the company of its intentions before taking the matter to court. By not doing so, the agency denied Ripple what is known as fair notice. This powerful argument could go bust, though, if it turns out that Ripple knew it was possible the SEC would take issue with the status of the token. Peter Vogel, of counsel and a member of the Blockchain Task Force of Law firm Foley and Lardner, explained to Cointelegraph, quote, U.S. District Judge Annalisa Torres ruled that by February 17th, Ripple would have to make public sealed legal memos from 2012 from Ripple's lawyers advising Ripple before launching XRP. The SEC claims that Ripple was advised in 2012 that XRP would be deemed a security under federal law, so Ripple was well aware of the risk that the SEC would bring a lawsuit. Ripple claims that the 2012 legal memos related only to proprietary internal strategies. If the memos clearly point to the absence of a federal law violation, Ripple's argument will receive a massive boost. However, evidence suggesting that the firm's executives chose to ignore their lawyers' relevant concerns ahead of launching XRP could considerably deflate Ripple's fair notice argument. The company did, though, see the speech from William Hinman, the then director of the SEC's Division of Corporation Finance at the Yahoo Finance All Markets Summit in June 2018, as a notice to market participants about what the Commission does and does not consider a security. The regulator contends that these remarks reflected Hinman's personal position rather than the agency's. In a thriller plot twist, Judge Torres ordered the SEC to unseal email communications and staff notes related to Hinman's speech, an order that the Commission disputes. If the order stands, it could change the way executive agencies exercise a principle known as deliberative privilege. In common law systems, deliberative process privilege is a principle that protects information from public disclosure that shows the process by which an executive body reached a certain decision or policy. In the case at hand, the principle protects, say, internal documents that describe the SEC's thinking on how to categorize digital assets from normal discovery in civil litigations and Freedom of Information Act requests. But because the SEC argued that Hinman's remarks in question reflected his private opinion, deliberative privilege does not extend to the SEC's internal documents related to this speech, so the records are fair game. Amina Hassan, litigation partner with law firm Hughes, Hubbard, and Reed, thinks that the fight over the scope of the Commission's deliberative privilege is even more interesting than what's inside the 2012 memos. Hassan commented, quote, "If the court's decision stands, it could have a far-reaching impact, opening similar types of SEC and other agency documents to discovery. While any discovery disputes around agency notes will necessarily be fact-specific and resolved on a case-by-case basis, the decision does provide litigants a helpful hook to seek similar documents from the government. In other words, the precedent could open the door for crypto firms that will be fighting the SEC and other executive agencies in court in the future to demand the kind of information that was previously out of reach." Hassan added that Judge Torres's decision is also likely to cause agencies to reconsider, quote, "how they treat their officials' public speeches, which usually contain standard disclaimers that they express the views of the official only, not the agency." The fact that Ripple chose to engage in a court rather than going for a settlement right away does not rule out the possibility of a settlement at some point in the process. The legal experts who spoke to Cointelegraph on this matter believe that a settlement is still very much on the table. Vogel commented, quote, "Since about 95% of all lawsuits settle before trial, it seems likely that we will never have a jury trial. But the interpretation of these 2012 legal memos may be a factor in some settlement of the current SEC lawsuit." Hassan said that, quote, "It's difficult to say whether the case is close to resolution since the discovery and pleading disputes are continuing, but the stakes are very high for both parties, so we cannot rule out a settlement. Even if Ripple's side chooses to settle without a trial at some point in the process, the litigation has already demonstrated that a well-resourced crypto company can cause the SEC serious trouble in an open fight." All right, so there's a lot to unpack there. I think probably the main takeaway from this, for me at least, is it has to do with these 2012 legal memos and how those are ultimately interpreted, right? So if it's revealed that Ripple did indeed know or anticipate that releasing the XRP token would more likely than not mean that it would be deemed a security by the SEC's standards and practices, then that really wouldn't bode well for Ripple's case. And if that were to happen, it would be much more likely that Ripple would try to settle this matter rather than pushing it forward and trying to actually get the case heard on the merits. And that would result in some sort of precedent that would affect all future cases that have to deal with similar issues. But at the same point in time, when we're talking about this whole administrative privilege issue in terms of how it is to be interpreted, what that official from the SEC did and whether or not that was internal policy or just personal conjecture on behalf of the individual, that could also kind of weigh in the other favor. So that would benefit Ripple. And then if that were to weigh in Ripple's favor, they would be much less likely to want to settle and then take this all the way and actually get it heard on the merits, right? So you have these two issues kind of floating out there, the privilege and the memo, and they both, depending on how they end up shaking out, could sway the balance of power in either party's favor. Where the memo, if that turns out it's damaging to Ripple, then the SEC would have the leverage. Conversely, if it's determined that this privilege extended to these administrative agencies, if that bodes in Ripple's favor, then the balance of power, that pendulum would swing back over to Ripple, and then they would have the leverage, right? So this case really kind of stands at a crossroads now, where depending on how these important issues play out, the memo and the privilege, it could really shape the entire balance of power in this entire case and really set the tone for how this will shape out going forward. So turning here to the docket, we can see that this is the docket for the case, and this case it's pretty involved. I mean, there's 3 pages of these docket entries, and we're on the 3rd page here. Scrolling down to the bottom, we could see that most recently the SEC was trying to get an extension of time to file pleadings with the court related to this privilege that it's asserting. Ripple tried to prevent the SEC from actually getting this extension, but it appears here that they got it. There's a docket entry dated February 11, 2022. It's an order granting letter motion for an extension of time, and they ordered the SEC to file their pleading by February 24th of 2022, right? And then also there are some other really, I guess, relevant pleadings that were filed. We have here number 413. I think we could see it's an order on this privilege assertion by the SEC. We could see it right here. This was by the magistrate judge, and it pretty much states that Ripple seeks an order compelling the Securities and Exchange Commission to produce certain documents that the SEC has asserted are protected by deliberative process privilege. The motion is granted in part and denied in part, right? And so it kind of feels like, the judge is kind of weighing both sides somewhat fairly. I know here we have another one. This is, like I was talking earlier, how the Ripple Labs was trying to oppose the SEC's request for an extension. We could see that here. So I mean, these two parties are still kind of duking it out. Ultimately, it's impossible to tell how this is going to shake out. I guess anyone's guess is as good as mine. We're just going to have to see. I think only time will tell. And anybody that would want to tell you affirmatively how this is going to shake out is probably just guessing. But this is where we stand now. I think, like I said, only time will tell, and we'll just have to keep you guys updated as this develops. But I mean, this is a pretty pivotal case in the digital asset space, and I think that if it actually does get heard on the merits, then it would likely serve as a pretty strong precedent for all of the related cases that come after. So with that said, I hope you guys enjoyed this content. If you did, please hit that like button and subscribe to our channel. And thanks again for watching, and we'll see you all in the next video.